Hi everyone, I'm Advocate Tasmin from NRI Legal Services. Today we are going to be discussing about sale deeds and gift deeds, their key differences as well as their tax implications. We get a lot of questions about this topic. There seems to be a lot of confusion between the two, and hence I will apprise you about everything you need to know. Let's start with gift deed. What is a gift deed? A gift deed is basically a legal document through which the owner of an immovable or movable property transfers his or her property to another person without any consideration voluntarily. Though it is not compulsory to execute a gift deed while gifting any asset, it does create a valid documentary record. A donor is a person giving the gift. A donee is a person who receives the gift. A gift is classified in the following ways from a taxation perspective. Number one, money that is given without consideration is called a monetary gift. Number two, the term gift of movable property refers to movable properties received without consideration. Number three, gift of immovable property refers to immovable property received without consideration. A gift deed includes the following clauses. Number one, details of donor and donee. Number two, consideration. The donor should indicate that he is transferring the property out of love and affection towards the donee, and no other consideration of any type is involved. Number three, donor should specify that it is a voluntary transfer and not due to any fear, coercion or threat. Number four, ownership of property. Number five, property details. Number six, rights of the donee. Number seven, acceptance by donee. Number eight, intention, which is it should be expressly or implicitly stated the intention to transfer possession of the gifted property. Number nine, witnesses. A minimum of 2 witnesses must sign and attest the document. Number 10, revocation. Now, the gift deed does not have to contain a revocation clause, but you can revoke it in future under certain circumstances. The complete process of gifting through a gift deed can be divided into 3 steps. They are drafting of a gift deed, in which drafting of the deed is usually done through a lawyer. The draft of the gift deed suggests the transfer of property from the donor to the donee. The gift deed should have been drafted as per the Indian Registration Act 1908. Number 2, acceptance of gift. The signature of the donee is needed for acceptance of the gift deed. One essential factor is that the gift should be accepted during the lifetime of the donor. Number 3, registration of deed. Stamp duty has to be paid corresponding to the value of the gift. The document also requires the signature of witnesses along with the signature of the donor and donee. Registration is done as per the provisions of the Indian Registration Act 1908 and the Transfer of Property Act. Unless the registration of the gift deed is completed, the title does not pass on to the donee for an immovable property. Now, points to note. Minors are not legally capable of signing contracts, so they cannot make gift deeds. On behalf of the minor, the guardian may accept a gift but cannot gift a minor's property to someone else. Number 2, once a gift has been given, it cannot be withdrawn. Number 3, gifts made to specified relatives, which are mentioned in the Income Tax Act, are exempted from tax in the hands of the donee. Types of gifts: non-taxable gifts and taxable gifts. Non-taxable gifts. Individuals will not be charged tax on monetary gifts or immovable property or prescribed movable property received as gifts in the following cases. Number 1, a gift received from a blood relative. Number 2, money received by the individual on the occasion of his or her marriage. Number 3, money received in a will or as an inheritance. Number 4, money received in contemplation of the demise of the payer or donor. Number 5, money received from a local authority as described in the explanation to Section 10, Clause 20 of the Income Tax Act. Number 6, money received from any foundation fund, university, hospital or other medical institutions, other educational institutions or any trust or institutions referred to in Section 10, Clause 23C of the Income Tax Act. Number 7. Money received from a trust or institution registered under Section 12AA or Section 12AB of the Income Tax Act. Number 8. Shares received in connection with a demerger or a merger of a company under Section 47, Clause 6D or Clause 7, respectively, of the Income Tax Act. Number 9. Under Section 47, 6CB of the Income Tax Act, shares received as a result of a business reorganization of a cooperative bank. Now, taxable gifts. Other than the above exempted category, the following kinds of gifts are taxable in the hands of the recipients. Number 1, money. Money can be given in cash, by check, or electronically. If the aggregate value of the monetary gift received during the year by an individual or Hindu undivided family exceeds Rs 50,000 and the gifts discussed above, then gifts, whether received from India or abroad, will be charged to tax as income from other sources. Number 2, immovable property. Individuals may receive land or buildings as gifts for inadequate consideration or without consideration at all. But in the following cases, gifts of immovable property will not be charged to tax. Now, taxability of immovable property received without consideration is that in this case, whether the property is received without consideration, that is without payment, and the stamp duty value, that is the value adopted by the authorities to calculate the stamp duty, exceeds Rs 50,000, then the entire stamp duty value of the property is chargeable to tax. Taxability in a case where an immovable property is received for less than its stamp duty value. In this, if the following conditions are satisfied, then immovable property received by an individual or a Hindu undivided family or less than its stamp duty value will be charged to tax. Number 1. Any immovable properties acquired by an individual or a Hindu undivided family. Number 2. The immovable property is a capital asset within the meaning of Section 2, Clause 14 of the Act for such an individual or Hindu undivided family. Number 3. Such property is acquired for a consideration, but the consideration is less than the stamp duty value and the difference exceeds Rs 50,000 and 10% of the actual consideration. In other words, if an individual purchases a capital asset being an immovable property and the stamp duty value of such property exceeds actual consideration by Rs 50,000 and 10% of the actual consideration, then the excess of stamp duty value over the purchase price will be charged to tax in the hands of the purchaser. Number 3, movable property. Prescribed movable property includes shares, securities, jewelry, archaeological collections, drawings, paintings, sculptures, or any work of art, and bullion being capital asset of the taxpayer. If the following conditions are satisfied, then value of the prescribed movable property received by an individual or HUF, which is Hindu undivided family, will be charged a tax. Number 1, prescribed movable property is received without consideration, that is received as gift. Number 2, the aggregate fair market value of such property received by the taxpayer during the year exceeds Rs 50,000. In the above case, the whole amount of the fair market value, not the difference between the fair market value and 50,000 of the prescribed movable property, will be treated as income of the receiver. Now, provisions regarding stamp duty. Consideration of stamp duty value is similar to the provisions under Section 50C of the Indian Registration Act 1908. Let us discuss in brief this provision for the gift tax purposes below. Stamp duty value needs to be taken into account when computing gift tax on immovable property. Stamp duty values, however, can be higher for numerous reasons, and one of them is a considerable period of time between the date of agreement and the date of registration. The following conditions must be met for stamp duty value to be considered for gift tax purposes. Number one, there's a difference between the date of such an agreement and the date of registration. Number two, the consideration is either fully or partially paid with an account payee check, bank draft, or electronically through a bank account on or before the date of transfer agreement. Now, let's talk about sale deed. Sale deed. The meaning of sale deed refers to a legal document that outlines the terms and conditions of the sale. It is executed by the seller and the buyer for the transfer of ownership of the property. It outlines the important information regarding the price to be paid for buying the property, description of the property, how and when the property ownership will get transferred to the buyer, etc. It is an essential document as it is the proof of ownership of the property. It legally reports the proof of the sale of property from the seller to the buyer. The sale purchase of the property is not legally complete until the sale deed is signed by the buyer and the seller and is registered. Now, how is a sale deed executed? Number one, as per the Indian Registration Act 1908, an agreement for the transfer of an interest in immovable property of value more than ₹100 is required to be registered. Thus, the sale deed of a property such as a flat, building or land must be registered for the sale to be legally valid. The sale deed is executed by two parties, that is seller and buyer. The seller is the person who is selling or transferring his or her ownership of a property. The buyer is the person who is purchasing the ownership of the property for a consideration. Number two, the sale deed must be registered in the local sub-registrar's office. An unregistered sale deed has no value in the eyes of law. The sale deed is made on a non-judicial stamp paper that is purchased as per the value prescribed by the stamp duty of a state. Number three, the amount of stamp duty levied on properties differs from one state to another. The charges on stamp duty vary from 4% to 6% on the property value. The sale purchase of a property is valid when the sale deed is registered in the sub-registrar's office when the buyer and seller both sign in the presence of two witnesses. Now, elements of a sale deed. The sale deed must contain these elements. Number one, name and address of executing parties. Number two, description of the property. Number three, sale consideration. The sale price agreed between a buyer and the seller, that is the amount which the buyer has to pay to the seller upon the execution of the sale deed. It must be mentioned in the sale deed. Also, if any advance has already been paid, it should also be specified in the deed. The mode of payment, such as through a check, demand draft, or an online transfer, is also important and should be mentioned in the sale deed. If the sale amount is paid in installments, the date of each installment should also be mentioned in the deed. It should mention the receipts of the sale transaction. Number four, passing the title. The sale deed should specify the time when the title of the property will get transferred to the buyer. All the documents related to the property must also be handed over to the buyer. It should provide the information that the possession of the property will be transferred to the buyer by the seller after the completion of the registration process. It should also state the actual date of delivery of possession of the property. Now, number five, indemnity. Make sure that the title of the property is free from any charges, litigation or encumbrances, that is, any other person does not have a right to the property to be transferred to the buyer. In case such a situation arises, the seller shall be made liable to indemnify the buyer against any loss. The seller should clear all statutory charges such as property tax, electricity bills, water bills, society, maintenance charges and all other dues before the sale deed is executed. It ensures that the seller frees the buyers from all the previous loans, taxes, charges related to the property. Number six, registration. A sale deed is not legally binding unless it is registered in the sub-registrar's office. Both the buyer and the seller along with their witnesses must be present at the registrar's office on the fixed date for the registration of the deed. The stamp duty and registration fees have to be paid for getting the registration done. Now to compare sale deed versus gift deed, an exchange of property where money is involved, no matter how insignificant, would qualify as sale under the provisions of the existing laws in India. As a result of this, the stamp duty calculations will be different for the buyer of a property. Similarly, the person selling the property will be responsible to pay the applicable capital gains tax. In case of gifting, stamp duty rates are lower as compared to the sale. In gifting, capital gains tax is not applicable either, considering the donor of the property does not make any profit through exchange. Now to conclude, unlike a sale deed, the donor of a gift does not receive money. Number 2, stamp duty rates are higher for sale deed. In some states, there is no stamp duty on the property for gifting amongst relatives. And lastly, sale attracts capital gains tax. No such tax is applicable on property gifting. If you found this video informative, please like, share and comment below. And if you have any questions regarding gift deeds and sale deeds, you can write to us on query@nrilegalservices.com. Thank you.